In this video presentation, we are going to see the rule of law under the Constitution of India. Let us see first the meaning of the expression rule of law. The expression rule of law has been derived from the French phrase la principle de légalité, which means the government based on the principles of law. In simple words, the rule of law means the state is governed by the law and not by any person, and also no person is immune to the law. According to the rule of law, king is not the law, but law is the king. As far as Dice's concept of the rule of law is concerned, it is based on the three main principles. First principle is the supremacy of law, second equality before law, and third one is the predominance of the legal spirit. In the Constitution of India, we cannot see the expression rule of law directly, but it seems that the framers of the Constitution were well versed, were well acknowledged with the concept of the rule of law. It can be seen from the preamble itself. The words justice, liberty, and equality present in the preamble shows direct connection with the concept of the rule of law. Human rights and the rule of law are the two sides of the same coin. Human rights are enshrined in the Constitution of India in Part 3 in the form of fundamental rights which are enforceable in the court of law. Now let us talk about the golden triangle of the Constitution, that is Article 14, Article 19 and Article 21. According to Article 14, the state shall not deny to any person equality before the law or equal protection of laws within the territory of India. There are two concepts involved in Article 14, that is equality before law and equal protection of laws. Article 14 embodies the general principle of equality before law and prohibits the unreasonable discrimination between people. This article resembles to the Dacian concept of the rule of law. In Ashutosh Gupta versus State of Rajasthan, it was observed that there is close nexus between the equality before law and the rule of law. Certain freedoms are necessary for healthy democracy. Article 19 provides various freedoms to the individual which can be curtailed only on the basis of reasonableness. The fundamental right to life and personal liberty is provided under Article 21 of the Constitution. This article says that no person shall be deprived of his life and liberty except by the procedure established by law. Thus, this article indirectly makes the law supreme. Article 32 deals with the right to constitutional remedies. It affirms the right to move to the Supreme Court by the appropriate proceedings for the enforcement of the fundamental rights conferred in the Part 3 of the Constitution. This article clearly observes the rule of law and considered as the soul of the Indian Constitution. In various judgments, Honorable Supreme Court has expressed its views on rule of law and its position in India and in Indian Constitution. Let us see first, in A.K. Krepak versus Union of India, it was observed that under our Constitution, the rule of law pervades over the entire field of administration. Every organ of the state under our Constitution is regulated and controlled by the rule of law. In various judgments, it is observed that absence of arbitrariness is one of the essentials of the rule of law. In E.P. Royappa versus State of Tamil Nadu, it was said that equality and arbitrariness are sworn enemies. One belongs to the rule of law in the republic, while the other to the whim and caprice of the absolute monarch. In S.P. Gupta versus Union of India, the relation between rule of law and the Constitution and also the role of judiciary to observe the rule of law is expressed in these words. If there is one principle which runs through the entire fabric of the Constitution, it is the rule of law, and under the Constitution, it is the judiciary which is entrusted with the task of keeping every organ of the state within the limits of the law and thereby making the rule of law meaningful and effective. Independent judiciary is one of the basic structure of the Indian Constitution. Article 50 also talks about it. Same was held in Subcommittee on Judicial Accountability versus Union of India, as the rule of law is a basic feature of the Constitution which permeates the whole of the constitutional fabric and is an integral part of the constitutional structure. Independence of the judiciary is an essential attribute of the rule of law. While in Union of India versus Madras Bar Association, the importance of judiciary in the rule of law is explained, it is said that the guarantee of the equality before law under Article 14 of the Constitution is a facet of the rule of law which requires the adjudication of fundamental rights before an independent judicial forum. In ADM Jabalpur versus Shivakant Shukla, which is famous habeas corpus case, it was held that the Constitution is the rule of law. There cannot be any rule of law other than the constitutional rule of law, and Article 21 is our rule of law regarding the life and liberty. No other rule of law can have separate existence as a distinct right. While overruling the decision taken in ADM Jabalpur versus Shivakanta Shukla case, in K.S. Puttaswamy versus Union of India, it was held that Article 21 cannot be considered to be the sole repository of the right to life and personal liberty. It is the most precious right of the human beings in civilized societies governed by the rule of law. Thus, while deciding this case, the importance is given to the concept of rule of law while interpretation of the law. By considering the words of the Constitution and the various judicial views, we may conclude that the rule of law is indeed the part of the Indian Constitution, and judicial activism, public interest litigation are the outcomes of the observance of the rule of law in India.